is News at Noon on Leadership Television. My name is Winifred Ugwebo. The 10th leader of the indigenous people of Biafra, IPOB, Mazi Nnamdi Kanu, has filed a fresh motion before the Federal High Court in Abuja seeking the dismissal of all charges against him and his immediate release. In the motion dated October 30, 2025, entitled Motion on Notice and Written Address in Support, Kanu argued that there is no valid charge against him under any existing law in Nigeria. He said the charges currently before the court are a nullity ab initio for want of any extant legal foundation. The IPOB leader, who is representing himself, filed a motion under sections 1366B and 3612 of the 1999 Constitution, the Evidence Act 2011, and the Terrorism Prevention and Prohibition Act 2022. He maintained that the prosecution relied on repealed and non-existent laws, including the Customs and Exercise Management Act, (SEMA), which was repealed by the Nigerian Customs Service Act 2023, and the Terrorism Prevention Amendment Act 2013, repealed by the TPPA 2022. Kanu said the reliance on such repealed laws violates Section 3612 of the Constitution, which prohibits trial for an offense not defined under an existing law. He therefore urged the court to strike out the charges in their entirety, insisting they do not constitute any offense known to law. Citing the Supreme Court's decision in FRON versus Kanu, Supreme Court CR/1361/2022, he argued that lower courts are bound to take judicial notice of repealed laws under Section 122 of the Evidence Act 2011, adding that failure to do so renders all proceedings void. Kanu also contended that the counts against him were allegedly committed in Kenya in violation of Section 76(1)(d) 3 of the TPPA 2022, which requires validation by a Kenyan court before such acts can be tried in Nigeria. He said this omission nullifies the court's extraterritorial jurisdiction and breaches Article 7(2) of the African Charter on Human and People's Rights. He further maintained that under Sections 1(3) and 36(12) of the Constitution, any law or judicial act inconsistent with the Constitution is void. He cited previous court decisions such as Aoko versus Fagbemi, 1961, 1, all NLR 400, and FRON versus Ifegu, 2003, 15, NWLRO, Part 842-113, where convictions based on non-existent laws were nullified. Kanu urged the court to direct the prosecution to respond to his motion strictly on points of law within 3 days and to deliver a ruling on or before November 4, 2025. He stated that his application raises only constitutional and legal questions derived from existing laws and therefore does not require an affidavit. And that concludes the news at noon on Leadership Television. For more, log in to www.leadership.ng. Thanks for joining us.
Thank you.